from the daily list. Item number 1.
Yes.
My lord, this may the short issue involved in this case is, my lord, we are challenging the amendment of the act passed by the district council. My lord, briefly, the Khasia's Autonomous District Council election and nomination of the chief, deputy chief, and electors of the Maharam Semshi Act 2006 was passed by the district council for regulating the election of the traditional heads. Well, in 2014, the district council proposed for amendment, and district council passed the bill and forwarded to the governor. And the governor has returned back the bill without giving his assent. And thereafter, well, 2019, the district council introduced another amendment bill again. And 2019, district council passed the amendment bill, and under the rules, it has to send to the governor for his assent.
How many respondents are there?
Well, the state respondent as well as the district council. State has chosen not to file the.
All of them have been served?
Yes, yes, yes.
All of them have been served. Who is appealing for 1 and 2?
The state, well, all throughout they have been
State
appealing.
is not going to file the objections.
Yes, they have.
They have not filed.
They have not filed. Yeah, so
File.
they did not file. Earlier occasion, they made a submission that they are not willing to file the counter.
They have stated. Huh?
Yes.
After it was always filed, the request of state to file objections. Post on 16/4.
Today is 15th.
15/5. The matter came last on 14/3 and posted to 16/4.
Yeah.
There's no recording.
Those previous states that they made a submission that they are not willing to file. Perhaps it is not recorded, but they made a submission. Because of that.
Where is the state today?
Where is the state?
Normally, it's the Advocate General should be present whenever there's a challenge to an act. And in this case, it was assented by the governor.
It should be there.
State should be there.
Yes.
Chief Secretary to Government, Meghalaya, and Under Secretary, Joint Secretary, Government. 1 and 2, you are appearing.
My lord, I'll appeal.
So you are not filing any objections.
My lord, as per the last order, yes, my lord, we won't be filing any.
Don't record it. The matter is taken up today. It is represented by the state that respondent 1 and 2 are not going to file counter objections to the affidavit filed by the lead petitioner, and that they are going to adopt the objections filed by respondent 3 to 7. Post the matter for hearing on sometime in June. June?
Yes.
Shorter date, Your Lordship, this is a very limited issue.
Days, so June 1st week, 2nd week, whatever date.
No, okay. Take it.
Thank you.
All right.
Item number 2.
Post it on 18th June.
My lord, this is the case where the clan land in the Garo Hills are involved. There are so many markets established by the respective clans in their own land. Many markets are there which have been established by the clan in their own land, my lord. So our problem is that the district council, without even owning the land or without acquiring the land or establishing the market, they auction our markets and collect the revenue therefrom. So to which my learned friend district council, they say that we have passed a law wherein we have been authorized to collect revenue or auction the market, my lord. And we have got the concurrence of the assent was granted by the governor. So therefore, we are armed with the law and we can do like that. This is the case.
Article 71.
That is right. 1931, right. Annexure 2 or 3, no, remember.
Yeah.
Page 21 and 29 is question.
Yes.
Yes,
My lord, in pursuance to
you ready? Both of you ready?
yes, my lord. But here, my lord, since the assent was given by the governor, AG's presence will also be needed, my lord, because they are challenging the virus of the act.
AG is not here.
Others, we are ready, my lord, we can do a preliminary hearing or something. If
Not preliminary, we want to complete the hearing. Why should they know? See, you probably would have seen, many cases, I'm dictating the open court. We'll be dictating the open court.
At least the AG should be there. Where's the additional advocate general?
Report to that. Here's one of his daughter's communication. Where is Mr. Khan? He's also not available.
I can request him, my lords. I can request him to appear on the next.
He can represent, but he's going to argue the point.
State is a formal party again. He's on his legs in court number 3. He's on.
Where did they say it's a formal party? Shall you record that the state is a formal party and that you are not going to file any objections?
My lords, we've not filed any objection, my lords.
Shall you record it?
Lordship.
But the
We
virus,
asked this AG to appear, but as far as an objection is concerned, my lords, we've not filed anything. Kindly see the prayer.
Anyway, it's your. Prayer.
At page 14 and 15. One, they challenging the bias of the regulation introduced by the district council, and next is to set aside a tender notice issued by the district council again.
See, the annexure number 3 is the tender notice based on this enactment regulation. Correct?
Lordship.
my lord.
And this has received the assent of the governor.
Yes.
The state is not going to make any submission.
So, well, what I'll do is I'll take instructions from the AG. Can you have it on the next day? Can you have it next week, my lords? One more thing, my lord, that now tender has been settled with different parties, my lessees. Whether their presence will also be required or not.
Tenders have already been.
Yes, my lord. Yes.
They should also be heard.
Yes, my lord. Lessees are 182 lessees are there, my lord. 182 lessees are there. They are.
To serve so many.
So now we have to make all of them parties here.
Has to, my lord.
Give the details
My lord, we will supply the details to them. We'll supply. Let them.
so that you can make.
Yes, necessary amendment.
Tender has been finalized.
Yes, and settle, my lord.
Oh.
It's for 1 year, correct?
1 year.
1 year, my lord. By the time it come up for hearing, 1 year will be over.
1 year will go.
We have enough time, my lord.
No. When was the tender? When was it given?
Till 31st of March 2025, my lord, tender terms. Page 29, my lord.
Yes. 31st March. By the time the notice goes to the 182 persons, it will
Yes.
come, 1 year period will go.
It will lapse.
But without hearing them, adverse order cannot be passed.
We can do, my lord, and let it be published in the newspaper. All of them.
No. Is there any provision in Tamil Nadu, in Madras High Court,
Yes.
there's a provision in the rules, in the section of the Rule 2 capital A. 2 capital B is for purpose of joining together to file a single writ petition.
Yes.
2 capital A is permitting and one respondent to represent on behalf of others. Is there any provision like this?
No such provision, my lord.
Then you'll have to- unless such a provision is available, it cannot be a representative capacity also. And first you'll have to notice, you'll have to go. If the notice doesn't reach them, then you'll have to issue paper publication.
Yes, ma'am. That's
In fact, that provision is very good. Of Rule 5 of the Appendix Rules. Here notice will be ordered, and after one party comes, then paper publication will be. 2B will be ordered immediately. The court will satisfy, pay one court fee or separate court fee and take up the matter. Insofar as the 2A petition is concerned, one can be a representative, will come as a representative capacity. Then the court will order notice. Thereafter, direct them to effect paper publication. I think we have passed an order. We get that order so that we can give it to them. It is represented by the counsel appearing for respondent 2 or 3 to so and so, that tender has already been allotted to 182 persons.
Yes, my lord.
182 persons, and that they have to be heard. The counsel for the petition would submit that if the details are given, they file a petition to implement the parties to the proceedings. Full stop. The counsel appearing for the state submitted that since the Advocate General is not available, he'll get appropriate instruction. The counsel representing Advocate General submitted that he'll get appropriate instruction and report to the court as to whether they are going to file any objections on behalf of respondent 1 and 2.
Only one, my lord. Only one, my
Only
lord.
one, no?
I'm for 2, 3, and 4, my lord.
Oh, yes. Respondent 2 to so and so submitted that. Who's the matter? When will you give the details so that he can file a petition? Notice will have to go.
Monday I will give all the details, my lord.
Give the details. We'll call the matter on 27th.
My lord. On 27th, sorry, my lord. On 20th, my lord, I will give all the details.
Give all the details so that let him file. It has got to be numbered
My lord.
and matter has got to be listed.
My lord.
This is the matter on 27th.
My lord.
One matter.
Leave to matter.
Oh, one and two. Second matter. That is Madras High Court appellate side rules. Rule 2A and Rule 2B. Ask him to take a printout. It will be helpful.
Some supplementary list. Item number 1.
Please, Your Lordship. This PIL pertains to the felling of trees in Shillong, my lords, in an area called New Colony. Now, copies to the what is happening is there is a law in place, my lords. For felling a tree, there is a requirement to make an application to the Forest Department, my lords. Forest Department is to make an inquiry, and only after the, my lords, a satisfactory report is there that the tree actually needs to be felled, my lords.
Suppose the tree has
Permission is to be
already
granted.
fallen.
I'm sorry,
It has
my
got to be removed, no? Suppose the tree has already fallen.
If it is fallen, my lords, then it will not come within the purview of Section 3, but these are trees, my lords, which have been
Standing
felled.
trees they are cutting.
Standing trees have been felled. As a matter of fact, I can just show your lordship, the stump is still showing.
Take notice. Notice.
Balance.
This is your lordship. Lordship, I would like to raise the maintainability of this PIL, your lordship, because your lordship, this is not a public interest litigation, your lordship. Lordship, can you see the High Court rule of 2013? Lordship, kindly come to Rule 10B, your lordship. 1 IB, your lordship.
One. Rule 10.
Rule 10 IB, your lordship. A specific abandonment.
Rule 10.
Lordship, if lordship is having the High Court rule, then it at page 192.
Rule 10.
Lordship, yes.
Rule 10 deals with the opinion of judge.
Lordship, if lordship is having the High Court rules, then it's at page 192.
192.
Lordship, yes. A specific abandonment, your lordship, to the effect that the petitioner has no personal interest litigation.
1 minute, sir. 1 minute. Yes.
Lordship, a specific abandonment in para 1 of the writ petition to the effect that the writ petitioner has no personal
No,
interest.
10. 1.
10 IB, your lordship.
Right, D.
B, your lordship, B. A specific abandonment, your lordship.
No personal interest litigation that's not gated by self gain or gain. There's no motive other than a public interest in filing the petition. Yes.
Lordship, a statement to that effect has been made in para 2 of the PIL, your lordship. In fact, your lordship, I have a little instruction, your lordship. A prelim instruction, your lordship. Page 6. No?
No personal interest. The government is here.
Lordship, yes. I'm coming to that, your lordship.
In terms of Rule 10.
Page 6. These are the prelim instruction, your lordship. If lordship kindly lordship kindly come to page 6 of that instruction.
Page 6. Yes.
Lordship, yes. That is the letter dated 18/9/2023, written by the PIL petitioner, your lordship. May I read it, your lordship?
My mother specifically that the tree was not cut to liquid authorities at the time. And then standing and that's the reason. Yeah, this is in 2023.
Lordship, yes. This is all 2023, your lordship. Lordship, kindly see abandonment at para 9 of the PIL petition, your lordship. At page 9.
Page 9, para 9.
Lordship, para 9 of the PIL petition, your lordship. It's only one tree, your lordship.
1 minute.
No, that was, well, an incident that happened. in-
1 minute, sir, 1 minute.
Well, it's-
Who was this person who made a complaint?
The Lordship, kindly,
Who is the
you
petitioner here?
kindly come to page 1, Your Lordship.
Who is the petitioner herein?
No, Your Lordship, there was a complaint, Your Lordship, by a resident of that particular place, Your Lordship. Lordship will find it at page 1 of that, which the instruction which I have handed over to Your Lordship. Kindly come to page 1, Your Lordship, first.
No, sir. Please answer our question.
Lordship.
Who has given this complaint on 18th September 2023, which was received on 5th October 2023?
This, Your Lordship, 18 September 2023, this is the letter written by the PIL petitioner to the Chief Conservator of Forest, Your Lordship.
No, it cannot be a complainant, my lords. The question which is falling from your lordships is who's the complainant for felling the tree?
Huh?
I am not the complainant. I'm sorry, my lords, I don't have a copy of what my learned friend is referring to.
You file your objections.
Lordship, yes.
File your objection.
We'll file a short objection to this.
Government pleader.
If Lordship, kindly come first to page 1.
See, the full name is not here. Here it says
G. Shabong, Your Lordship.
Line G.
G. Shabong, Your Lordship.
Huh?
G. Shabong.
G. Shabong.
Yes, G. Shabong.
But the name is not clear.
Yes, Your Lordship.
My lords, this is one incident in para 9 in 2023, some tree had been cut down. That is not the cause of action for filing this PIL.
The entire incident, Your Lordship, was of 2000.
No, my lords. If your lordships kindly have a look at
One minute.
I'll just clarify, my lords.
1 minute, sir.
Para 8 and para 9, if your lordships kindly have a look of my PIL.
See, para 9, you have to establish that this is not a petition. He says, on the basis of a complaint filed by a resident, whether this person was a petitioner.
No, Your Lordship.
I'm not the complainant, my lords. What they're trying to say is this tree which was cut down in para 9 was in my land. So they're trying to say that I have some personal interest. Even what I'm trying to
You
submit.
are not a petitioner.
No, my lords, I was not the complainant. Somebody, what happens here, my lords, is I want to build a house. So I look at a healthy tree and I say I cut it
The
down.
person may have the same name.
No, Your Lordship.
No, the complainant was somebody else, my lords.
That's what you have stated in para 9.
My lords. What they're trying to say, my lords, is
What I'm trying
incident in para 9 relates to my land.
May I clarify, Your Lordship? What I would like to submit, Your Lordship.
Do you have the original copy? But please get
Lordship,
proper inspection
we-
because
Wasn't filed an objection.
no, your prima facie, I think your client has not properly instructed you. The complaint dated 18th September 23.
Marriage.
The signature found in that appears in that complaint, and the signature in the affidavit appears to be one of the same.
Well, if they file an objection, I will seek instructions specifically. But 18/9/2003, my lords, what had happened is, if I may just complete, the person across the road, my house is on the other side, my lords, across the road had filed a complaint whereby a tree standing on my land, which is adjoining the PWD road, was cut down. That's in para 9. I am not the complainant. What I'm saying is, my lords, that all trees are being cut down in an area without following the rules as envisaged under Section 3 of the Tree Preservation Act.
Suppose a tree is standing in your place
My lords,
and that has been cut
my
and
lords.
you are given a complaint. And the further trees are removed.
Not in my land, my lords.
Or some other place
My lords,
for which you are entitled to bring it to the notice of the court by means of a public interest litigation.
my lords.
For that, what you have to state is, in my land, this has happened. I have already lodged a complaint. Now, in several places, this is happening after September 2023. Hence, I am bringing it to notice of the court. That should be your argument. But in para number 9, it says, you are not the complainant. If you are the complainant, then the government is wrong.
Complainant, my lords, what happens is, for felling of a tree, somebody has to file a complaint. So the complainant will be XYZ, whoever, my lords. Then, once the tree is cut down, my lords, I filed a
No, senior advocate, we would like to ask you one question.
My lords.
Suppose you are the complainant.
for felling of a tree, my lords.
Yes, that one tree,
Lordships,
whatever it is. On 18 September 2023, a tree was cut
lordships,
illegally.
lordship,
If you have lodged a complaint,
lordships.
the government in para number 9 may be incorrect. You you file an affidavit as if somebody has given a complaint.
No, Lordship, what I mean to submit.
That's
your
the position,
Lordship,
somebody else complained.
What I mean to submit, your Lordship, by referring to para 9, your Lordship, what I mean is that this is not a public interest litigation, your Lordship. It is a personal litigation, your Lordship. By referring to that letter of 18 September 2023, your
That is
Lordship.
right, if see, you are giving, half of the letter.
My lords, the
How many
name,
companies-
my lords, I've got the name of the complainant. The name of the complainant as what's appearing in para 9 is Mr. John Ward Kharkungor.
Lordship, there was a complaint.
89, the cut one healthy tree was located on the side of the lower so on the basis of complaint filed by a resident of the locality.
Lordship, yes.
That resident of the locality is Mr. John Ward Kharkungor. not
That,
the-
Lordship, we will find at page 1 of my instruction.
That's not me.
At page 1 of my instruction, your Lordship. This has been addressed to the.
Any of file your objections.
Lord.
File your objections.
It's not me, my lords.
One minute. The for cutting down the healthy trees without authority, present public interest litigation has been filed to prevent further felling of trees. Government pleader took notice and submitted that rule number 10 within bracket I within bracket B of the Meghalaya High Court rules pertaining to filing of public interest litigation has not been complied with.
No, that is not my submission, your Lord.
1 minute, sir.
Oh, sorry.
Even though an averment has been made in para number 2 of the affidavit, that said provision has been complied with, for cutting down a tree. A complaint on 18/9/2023 has been given
Lordship.
by the writ petitioner,
Lordship, correct.
and that it will not amount to a public interest litigation.
Lordship, I am highly of my Lordship.
Correct?
Lordship, I am highly
We
of my
will
Lordship.
dictate. If we dictate wrongly, it's a ground for you to take it by way of
No,
the
I'm
Supreme
sorry,
Court.
Lordship. I'm highly of my Lordship.
You listen, that's why.
Lordship, I'm sorry, your Lord.
The counsel for the writ petitioner in response would submit that it is true that a tree at the residence of a person was cut illegally, for which a complaint was given on 18/9/2023, and the petitioner has not given the complaint.
It's one, my lords. The name of the complainant, I have it here, my lords. It's
And the
Mr.
name
John,
of the complainant is so and so.
Mr. John Ward Kharkungor.
Name of the complainant is so. Name of the complainant is so and so. The government pleader, in reply, would submit, drew the attention of this court to the communication dated 18 September 2023, to the effect that the complaint was given by the petitioner, and the name of the complainant is G.
G. Shabong, your Lordship.
What is it?
Geraldine Shabong, my lords.
G. Shabong, and the signature appear in the complainant and the affidavit is the same. Full stop. A part of the letter alone has been produced before this court, and hence we expect the respondent to file objection
Lordship.
and produce a clean copy of the same, and also furnish a copy of the objection and the document that is going to be relied upon by the government to the other side.
Lordship.
Post the matter sometime in June.
That's
Highly of my
obliged.
Item number 2.
Please, your lordship. It's a very limited issue involved over here. What had happened is, my lords, a writ petition came to be filed before the learned single judge with a limited prayer, my lords. that a complaint had been made against the private respondent number 6 and 7 until such time that against the private respondents number 6 and 7, my lords. Until such time that the complaint be disposed of, my lords, a certain amount of money which is to be allocated for works to the respondent number 6 and 7 should not be released. That was the limited issue before the learned single judge, my lords. The prayer in the writ petition, your lordships would find it at page 27 of my memo of appeal.
27.
My lords.
Please direct the respondent number 6 not release the pending funds until disposal of complaint data so and so, and the please direct the respondent initiate
Initiate
inquiry.
inquiry, my lords.
So why so and so?
So what happened, my lords, during currency of the writ petition, the inquiry was completed. So essentially, my lords, my writ petition becomes infructuous. The copy of the inquiry report was also furnished before the court. Now what has happened, my lords, is the learned single judge, while delivering the judgment, my lords, has gone into the legality or the illegality of the inquiry report, saying, my lords, that the inquiry has heard everybody, so everything is in order, nothing is to be there. What we are only submitting before your lordships is, my lords, we say that the inquiry was not done in a proper manner, but that would have to be agitated by me in an appropriate proceeding. I would have to come back before your lordships with a fresh writ petition challenging the inquiry, if at all, my lords, I am aggrieved by the inquiry. I'll take your lordships to the findings of the
Which on the
learned.
other side?
I'm for the state lordship.
Yes.
I am only, my lords, aggrieved by the observations in paras 7 and 8 of the judgment, my lords, at page 275.
1 minute. It was, despite having all- So the prayer is only to initiate the inquiry and complete it.
Completed lordship.
That is right.
My mind
According to
of the-
him, after the finding was rendered, it has got to be challenged. Without challenging that, the learned single judge has gone into the merits of the matter and rendered the finding that the inquiry is fair and proper.
Lordship, the inquiry report was not challenged by the petitioner before the single
That is right, that's what is this case.
lordship.
When there is not challenge, how can that finding can be rendered without a plea? The prayer is restricted only to the extent that the inquiry should be conducted.
Lordship.
After the inquiry report is received, he may submit a reply and you are entitled to pass orders.
Lordship.
Thereafter only it can be challenged.
My lord. But the report was placed before the Honorable Court, Lordship, and all were present, including the petitioner's Lordship.
No, pardon me?
Lordship, when the inquiry report was placed before the single bench, Lordship, everybody who was involved, all the concerned parties were present before the inquiry officer, Lordship. Accordingly, the same was submitted before this Honorable Court, Lordship, before the single bench, Lordship. And Lordship, with regard to the second portion of the prayer, Lordship,
Take the finding of the learned single judge.
Lordship.
Page 7, para 7 at page 275, my lords.
270?
5. Para 7 and 8, if your lordships can have a look.
75.
Para 8 is the finding given, my lords.
See, the learned single judge has gone into the merits, sir, with regard to the finding of the inquiry officer and recorded the finding. In all fairness, the writ petition has become infructuous.
At that stage, my lord, the
He was given the liberty to challenge the inquiry report and the further orders, if any, passed. Adverse order passed.
my lords, that's my limited prayer.
That's the only prayer. What do you say?
Lordship, there's also a second portion, Lordship, of the prayer,
Oh.
which relates to release of payment, Lordship.
That is different. That is only after the inquiry report comes whether the fund can be released or not. That is entirely different.
My lord, this was also before.
That was not answered by the learned single judge also.
No, Lordship, what had happened was when the case was pending before the single judge, Lordship, the areas that is for the work completed was released. The area was released, Lordship, but that is only for work completed. But they're coming again with the same prayer before this honorable court, my
My
lord.
lords, I am not on that. I am not even on that money releasing part. What I'm saying is, my lords, my writ became
It's
infructuous.
part of the prayer,
Second prayer is that with regard to release of money.
Lordship,
Single judge has not answered.
Lordship.
if anybody who has got grievance, he has to file a writ appeal challenging that the money has not been released. Correct?
Lordship.
Since the first part has already been complied with, namely the inquiry report has already been submitted,
Lordship.
against the inquiry report or the final order that may be passed on the inquiry report, it is for him to challenge in case of any adverse orders. That is not, the inquiry report is not subject matter of writ petition at all.
This,
It is not.
this
Agreed,
finding
Lordship. I have
forecloses
copied
my
the
right to
petition.
challenge that. It's complete.
When I'm against you, I'll ask you.
Well, my apology.
Lordship, the prayer before the single bench, Lordship, was to direct the respondents to initiate an inquiry against the respondent number 6 as to why funds of a total of so-and-so amount was released, Lordship, on so-and-so date. Lordship, the same prayer has been reflected in before the writ appeal, my lord. So the same prayer is also here before this honorable court, Lordship.
Page number?
Of the writ petition, Lordship. I'm sorry.
Page number,
Prayer
paragraph
and the
number.
appeal is at page 12.
Page?
12.
Page 12, Lordship.
Prayer and the appeal is at page 12. It's not the prayer.
So, Lordship, if I may, my lord,
Page 12.
Lordship.
Page 12 of my memo of appeal is my prayer.
Memo of appeal, page 12.
Lordship.
1 minute, 1 minute.
This is standard prayer with regard to the challenge. It's not specific.
Lordship, they're praying for setting aside of the order passed by the single judge,
That is
Lordship.
right.
But Lordship, the prayer before the single judge was to initiate, direct for inquiry. Lordship, that was completed, Lordship.
Correct.
So a portion of the prayer before the single judge has been completed by the state respondents,
Correct.
Lordship. Lordship. Now, the only line, Lordship, maybe as what has fallen from the Honorable Court's, your Lordship's mouth, is with regard to the later line of paragraph 7, and also that the findings contained here and have not revealed any
Not
irregularities.
a challenge at all.
But Lordship, the prayer has already been complied with, my Lord.
Which one? Yes,
With
that is
regard
right.
to inquiry report.
He also says that the prayer has been complied with.
Lordship,
Then the petition will become infructuous.
Lordship, exactly.
We agree with you. To that extent, we agree with you. Point raised by the senior advocate is that when I have sought for a prayer with regard to conduction of inquiry and the consequential relief, there is no prayer with regard to questioning the inquiry report, which was not at all available when the writ petition was filed. How can a learned judge go into that question in the writ petition? This is his argument.
Lordship. But a portion of the paragraph 7 has already been complied with, my Lord. That is my my submission before this honorable court, that what they have sought for from before the single bench has been complied with by the state
Madam,
respondents.
please take the order of the learned single judge.
Lordship.
Subject to what your friend is going to say, that must be his grievance. Which is the page number? Which page?
Page 275, my lord's
Paragraph 7, Lordship.
275.
275. See, take page 273.
Lordship.
The learned judge has extracted the report.
Lordship.
Correct?
My Lord.
To that extent, he is right.
Lordship.
But when there is no prayer about the inquiry report, questioning the inquiry report, why should there be a finding in para number 7 and 8? He should have said, since the inquiry report has been given, which is extracted below, the writ petition has become infructuous and leaving the parties to agitate if they have any grievance in the manner known to law. And that writ petition has become infructuous. That should be the wordings in the judgment. That is his argument. See, therefore, when the report is given, a detailed discussion is also required.
Lordship.
We will say that para number 7 and 8 is interfered with as the writ petition has become infructuous and it is open to him to challenge the inquiry proceedings and the consequential order, if any, passed on the report. We close the writ appeal. That's all.
Lordship, I would say yes, maybe paragraph 7, but paragraph 8, Lordship, in this view of the matter, as the complaints of the writ petitioners have been answered, Lordship, the writ petition indeed being frivolous, the same is not entertained inasmuch as adequate opportunity has been granted to the writ petitioners.
That is right. Para number 7 is also okay. Say it is also
It is
okay.
okay,
Para
Lordship.
number 7. Finding content therein, I have no idea. That is, how can there be a finding, madam,
Lordship,
when the prayer is not there?
Lordship. So it's only paragraph 7, Lordship.
Paragraph 7.
Para 8 also, is frivolous.
Paragraph 8, in view of the fact that
My writ
complainant
petition is
has been
declared
answered.
frivolous
No,
when
no.
it's something that has become
In view of
infructuous.
the matter, as the complainant of the writ petitioner have been answered, writ petition indeed it become frivolous, the same has not been entered.
Being frivolous, would be casting a,
at the time of inquiry.
being frivolous will be casting something against the writ petition, on a writ petition which is infructuous.
We will say that it will become infructuous, that's all.
Writ petition
It will
become
become
infructuous.
infructuous.
They can agitate the remedy appropriately, wherever.
Lordship, as per my very humble understanding, Lordship, the prayer of the writ petitioner before the single bench, as rightly has been recorded, my lord, has been answered, my lord. So what they are here before your honorable, before your lordship is paragraph 7, my lord, not paragraph 8.
No, para 8, if something is rendered infructuous, how can it be frivolous?
See, you must understand, adequate opportunity had been granted to the writ petitioner at the time of inquiry. Whether it been given or not, it has got to be answered in another writ petition, not in the same writ petition.
Lordship,
The validity.
what is meant by adequate opportunity, Lordship, is that all parties were present, all stakeholders were present during the inquiry, my
We
lord.
do not know.
Lordship is on record, my lord.
That
affidavit
means
is
you are
on
asking us to go into the finding of the inquiry report, which is not a prayer at all. Why should we do that?
The inquiry report has been recorded, Lordship. It's
Correct.
part of the judgment.
Madam, we are not saying anything at all. Up to the stage of recording the inquiry report is perfectly correct. But rendering a finding on the inquiry report, then that is not under challenge, needs to be interfered with. That is all. Come. The present writ petition, writ appeal has been filed against the order of the non single judge.
May I please, Your Lordship? I'm the caveator here, ma'am.
Give it on.
Yes, ma'am.
Yes.
Content 7 and 8. The VC Secretary and President, ma'am.
Yes.
The inquiry has been conducted and my lord, filed the report, my lord.
That's what. There is no
Irregularity, my lord.
After
Only
the,
with regard to
what,
para
no,
7.
no, after the inquiry report, any orders will be passed, you know.
No,
After the inquiry report,
no.
oh,
Money has been released, the job card holders' money has been released.
Those is all on the merits of the matter, I'm not on merits. I cannot be on merits at this stage before your lordships.
see, based on the inquiry report, the consequential relief has got to be given, is it not?
Not to me, to the job card holders.
Whatever it is. That has not been done.
Lordship, if I may, my lord, the statement over here is the writ petition indeed being frivolous. It's not about, it doesn't say anything about the inquiry report, Lordship.
Assuming that it's frivolous, appealing before this by way of writ petition become frivolous, to say that. But the subsequent wordings are not, the same is not entertained. I'll take it, we will take it. Then in as much as the problem arises there only. Adequate opportunity will be granted to the writ petition at the time of inquiry. Who will have to decide? Whether a single judge and division bench can decide.
Lordship. What I'm
Madam, and it
submitting,
is not under challenge.
Lordship. The inquiry report was not under challenge before the single bench, my
Correct.
lord.
That's what he also says.
Yes.
You also agree. We also agree.
So what the single judge has stated is that the writ petition is frivolous. Nothing is involving the inquiry report at paragraph 8, my lord.
The subsequent, we'll say that even assuming that the petition has become frivolous, there is no need to go into the inquiry report and render a finding that it has become, that sufficient opportunity has been given. This has got to be agitated in a separate petition.
Lordship, everything is on record, my lord.
Who is no?
Same
The
argument
affidavit,
with
the affidavit filed by the state lordship, we've already placed before the learned say single bench, honorable single bench, that all parties, all stakeholders have participated in the inquiry, my lord. And that has been accepted, lordship. At the time, because the judgment was rendered in the open court, lordship, that was accepted by all stakeholders, my lord.
Not by the petitioner.
Lordship, the petitioner was very much present in the court.
No, no,
lordship.
see, we argue. Then if all parties agree, why should there be an appeal?
Only subject to paragraph 7,
This
but
alone.
not paragraph 8.
Nothing
lordship.
else. We are not going to say anything at all. Come. The present appeal has been filed against the order of the learned single judge dated so and so. According to the writ petitioner appellant, petitioner has sought for the following prayer in the writ petition. Page number 27 of the typeset, para 15. You would further submit, the petitioner submit, the appellant submitted that the relief sought for in the writ petition was to initiate inquiry against the sixth respondent in the writ petition. And that inquiry has been completed, which was not challenged at all by the writ petitioner. According to the petitioner, even though the learned single judge was right in extracting the inquiry report dated 11/5/2023, rendering a finding on the inquiry report that there are no irregularities is not warranted, full stop. As long as the inquiry report is not challenged, the findings would affect them affect the appellant in case the said inquiry finding is challenged. Full stop. The counsel appearing for, you're appearing for?
7 and 8.
7?
7 and 8.
7 and 8.
Yes.
Would submit that due opportunity has been given to the petitioner, appellant, to participate in the inquiry, and after the inquiry report, a final decision is yet to be taken. The counsel appearing for
State lordship 1 to 6.
1 to 5,
1 to 6 lordship.
1 to 6,
Lordship.
would submit that all the parties have duly represented in the inquiry, including the petitioner, and finding has been rendered by means of an inquiry report on 11/5/2023. The learned judge, after going through the inquiry report, came to the conclusion that there are no irregularities and that the petitioner is not entitled to any relief and that the writ petition has to be dismissed as frivolous. Full stop. Heard all the parties. A reading of the prayer in the writ petition would make it very clear the petitioner has sought a relief with regard to conduction of inquiry, and at no point the inquiry finding is under challenge. Full stop. The appellant may or may not accept the findings of the inquiry officer as the inquiry report dated 11/5/2023. But however, when the same is not under challenge, holding that there are no irregularities at this stage when the same has not been challenged is not required. As a relief sought for the writ petitioner has become infructuous, we dismiss the writ petition, modify the order of the learned single judge in para number 7 and 8 by giving liberty to the petitioner to agitate the inquiry report and the findings, if any given, finding or order, if any given, based on the inquiry report. The writ appeal is disposed of in above terms. No question.
Much obliged, Lordship.
Item number 3.
If you admit the writ petition, we'll keep it for 10 years.
Item number 3.
This is the matter which came up last week, yesterday.
Yeah, yesterday it came up, Your Honor.
Which paragraph you are relying upon, sir? The citation?
If Your Lordship have the case law compilation.
So yesterday
This
we
is
were not
as-
happy. Yesterday we were not happy at all. You
I-
must
I-
allow
my
your junior- you
apology.
must allow your juniors to read the papers.
My apology, my sincere apology.
Not your apology. You, my
My
junior,
sister.
yesterday we wanted to impose cost on you to pay
My-
25,000 rupees to the juniors for not allowing the juniors to read. Yes.
My apology.
If senior is not going to allow the juniors to read the papers, then cost will be imposed on the senior.
My junior is there, then let my junior argue that. My junior is there with me. Let my junior.
Yes.
I think the mistake.
Which judgment, sir?
Item number 3 is page number 7 to 10.
Page number?
7 to 10 of the case law compilation, which has
7 to 10. That is Punjab Haryana High Court.
yes, Punjab Haryana High Court. There are 3 judgments which have been now SLP against which has been dismissed.
Page number. Which paragraph, sir?
If you will honor will start at the beginning on page 7, bottom para. The revenue is before us challenging order dated 30th November 2011 passed by the Income Tax Appellate Tribunal. Bench deed hereafter dismissing an appeal filed by the revenue, therefore confirming the order dated so and so. The counsel for the revenue submit the system maintain mercantile system. The mere fact received.
So this is
may
the
have
only
not been
judgment to
derived.
rely upon. With regard to issue number 3,
Yes, Your Honor.
this is the only judgment. Not the judgment of Supreme Court.
Then Excel Industry judgment is there, Your Lordship. There is another judgment, which is page number. Sorry. Page number 133, para 7.
Page 7.
Supreme Court judgment.
Page number?
It starts from page 33.
33.
133.
133 or 33?
133.
Oh, written it correctly. Yes.
And para 17 onward.
1 minute, sir. 1 minute. 133. In fact, I was asking you, we were asking you yesterday. Remember, your senior was referring to one Supreme Court judgment.
Yes, sir.
Yes.
And then Your Lordship may come to page 135, para 17.
Paragraph 18.
17.
17. Yes.
First of all, it is now well settled that income tax cannot be levied on hypothetical income in so and so. Income tax is a levy on income. No doubt the income tax takes into account 2 points of time at which the liability of tax is attracted. The accrual of the income or receipt. But the substance of the matter is the income. If income does not result at all, there cannot be a tax. Even though in bookkeeping the entry is made about a hypothetical income, which does not materialize. Where income has in fact been received and is subsequently given up in such circumstances that it remains the income of the recipient, even though given up, the tax may be payable. Where, however, the income can be said not to have resulted at all, there is obviously neither accrual nor receipt of income, even though an entry to that effect might in certain circumstances have been made in books of account. The above passage was cited with approval in Morbi Industries versus so and so, and in which the court also considered the dictionary meaning of the word accrue and held that income can be said to accrue when it becomes due. It was then observed that date of payment does not affect the accrual. The moment the income accrues so and so and so. And then para 19 this court further held, and then they have analyzed in para 27 all these three factors.
So according to
Applying-
this, finding of fact cannot be interfered with.
Yes, finding of fact cannot be interfered, and all three issues have been addressed by the ITAT in its order.
No, we are concerned about issue number 3 only, because we have framed the question with the question of law with regard to issue number 3 alone.
Yes, Your Honor.
Yes. What is this?
Obliged.
Next time when you come, we will not permit your senior to argue. You must prepare. an
Okay,
argument.
okay, yes. Obliged.
If anything is required, we will ask the senior to clarify. Yes.
Item number 4.
But this matter was listed yesterday. I prayed for listing along with 2 other matters. Those 2 matters are listed in the main list, my lord, today. Those are.
You are appearing in all the matters.
No, Your Lordship, only in 4, supplementary 4, I am appearing for the state respondent.
In the main list, item number 5 and 6, these are all similar matters, my lord.
Notice has been ordered,
My lord, there is a stay out of past by lordship in 5, 6.
but name has been prepared.
We have received the affidavit filed by the respondent number 3. The corrected copy is received only yesterday. We need 3 weeks time to file reply to it. Lord.
Yes, sir, thank you. What is the issue involved in this appeal?
But here, my lord, a demand notice has been issued under Meghalaya Value Added Tax Act after the limitation period of 5 years. My lord.
But,
In fact, this is issued after 14 years.
but Your Lordship, I beg to submit, Your Lordship, prior to issuance of final notice, Your Lordship, 3-4 times several notices were issued to the petitioner, but petitioner suppressing all this notice, last notice.
Find your objections.
Already filed, Your Lordship.
They filed.
I have already filed.
No, but the other council wants time. At the request of the council, appealing for the respondent to file the objection, pose the matter. What do you want?
Lordship, I am appearing for the petitioners in item
You are
number 5
appealing for
and
the
6.
petitioner. Oh, you have to file.
Respondent,
No, my lord, in item number 4, I am the petitioner, my lord.
Item number 4.
My lord, in the supplementary
1
list.
minute. 4.
JB Textiles, my lord.
JB Textiles, you are appealing for the
Petitioner, my lord.
petitioner, yes.
And in the main list,
State
I-
respondent,
You are for the?
respondents, Your Lord, state
You are
respondent.
appealing. In all the cases, you are appealing for the
No,
respondent.
Your Lord, only in this case only I am appearing for the state respondent.
So whether notice has been served on the respondent, sir, in your matters 5 and 6, you are appearing in 5
5 and 6. Lordship, 5 and 6, they have already filed affidavit. We need to file rejoinder, Lordship.
Oh, they filed a reply. Who is
Only
appealing for?
yesterday.
Who is appearing? Who is the counsel, sir?
Delhi, NC.
My lord, 5 and 6, my lord, I am appearing for the state, my lord. We have filed our affidavit, my lord, in this case.
So you want to file a rejoinder.
My lord.
Lordship.
At the request of the counsel appearing for the petitioner in item number 5 and 6, huh? 5 and 6.
Lordship.
Put the number. Don't put 5 and 6. Number so and so. Rejoinder. All the matter after 2 weeks.
Okay.
In June, sir.
Deep.
So the only with regard to the 5 years. After 5 years, they have no.
My lord, they cannot.
All the 3 cases.
All the 3 cases.
My lord, in our case, my lord, our stand is little different because in our case, my lord, our stand is little different. My lord, section 39 of the Meghalaya VAT Act, my lord, it does not provide limitation period because the limitation period that is provided under section 57, that is applicable only in cases of proceedings which are taken up under section 55 and 56.
So that limitation, my lord, will not be applicable in our case.
What is it? There is no limitation at all.
No limitation.
At any point of time, you can take initial action.
It says so, my lord. We'll-
That cannot be.
Present case also.
No, that cannot be.
Well, 5 years is the absolute limitation period.
That is
Under which provision?
The notices were issued.
Under which
Will
provision?
satisfy.
Get the VAT Act.
Section 39, my lord. That act.
Section 39.
Subsection 1.
Page number?
My lord, this section 39, my lord, the act my lord is holding is different. I have just taken a printout from online, my lord.
39 is security, scrutiny of return.
Scrutiny of return, my lord.
Oh.
Under this provision, my lord, clause 1, it says, each and every return in relation to any tax period furnished by a registered dealer to whom notice has been issued by the commissioner under section 35 shall be subject to scrutiny by the assessing authority to verify the correctness of calculations, applications of correct rate of tax and interest and input tax credit claimed therein, and full
So,
payment.
under this provision, any action has been initiated.
Yes, my lord.
Oh.
Notice was provided to them, my lord, served upon them, and then they
Where
are
is the 5-year period, sir?
My lord,
57, my lord.
57, my lord, section 64 again, my lord.
50?
57. But in my petition, I have quoted, my lord, lordship kindly.
No assessment under section 755 or 56. After your 5 years.
These are not proceeding under
1 minute, 1
55.
minute.
And appeal commission is also there. Commission.
Under 39, what is that you are going to do? What is that you have done?
My lord, we have sent them notice, my lord, thereafter scrutiny was conducted.
That is right, sir. Each and every return in relation to any tax period,
Any tax period, my lord.
any tax period,
Yes.
furnished by the registered dealer, whom notice has been issued by the commissioner under section 35.
Yes. We have sent them notice. my lord.
Said notice
Yes,
shall be subject to scrutiny by the assessing authority, verify the calculation. So this is in terms of section 35.
Right.
Under 35, which provision you have issued notice?
My lord, the notice is, my lord, in our affidavit which we have filed. At Annexure 1, my lord.
You tell us which provision.
Because we have given them notice, my lord, to produce their books of accounts. And accordingly, my lord, they have produced their books of account also, my lord.
For the purpose of,
For the purpose of, my lord, assessment.
for the purpose of assessing the tax payable under the act.
Right, my lord.
Correct?
Right.
So you have to read section 35 in conjunction with section 55 of the act.
My
It
lord,
cannot be read in isolation.
my lord, here, my lord, and that proceeding was taken under section 39. Now, my lord, section 55, my lord, relates to audit assessment, my lord. That power is exercisable by the Commissioner of Tax, my lord. Here, my lord, superintendent,
So registered dealer failed to submit so and so. And see, what is 55, sir? audit assessment,
Right.
where a registered dealer has failed to furnish any return under subsection 1 of section 35 in respect of any period. So, for this only, for not complying with section 35(1) or section 35, you have issued notice under section 39.
My lord, here proceeding was taken under section 39 only, my lord.
Correct.
And here, my lord, 39, the power under section 39 can be exercised by the superintendent of tax, my lord, and power under section 55 can be exercised only by the commissioner of tax, my lord. That is in terms of the schedule which is at chapter 2, my lord, of the rule.
But what do you mean to say that whoever it is, let A or B the authority?
Right.
Do you mean to say the 5-year period will not apply?
My lord, this 5-year period will be applicable only in cases where proceedings were initiated under section 55 or 56, my lord. 55 relates to audit assessment by the commissioner of tax, my lord, and 56 relates to assessment of dealer who fails to get himself registered. This is not the case in this instant case, my lord.
What is this, sir?
My lord, the notice, my lord, in my case, my lord, your lordship kindly turns to page 12.
Page
Page 12, my lord.
12.
After this.
This was a notice issued under section 36(4)(b).
Oh, 36(4)(b).
So, my lord, this was not the proceedings were not initiated under section 39, what they are referring to, my lord.
No, this is not.
My lord, the notice itself, whereas you have failed to furnish a true copy of the quarterly returns for the quarter ending June 2005 to June 2017, my lord.
36. Return defaults.
Lordship, still page 12, my lord.
Page 12, yes.
What it says, my lord, whereas you have failed to furnish a true copy of the quarterly returns for the quarter ending June 2005 to June 2017 within the time specified.
This notice has been issued by the superintendent. Superintendent has got a different powers and commissioner has different powers. In case the commissioner is going to decide the period of limitation, namely 5 years, will be applied only in those cases, not in cases where superintendent of tax deals with the issue. But this is the argument.
My lord, we will argue, we will place the judgment. There are judgments also, my lord. That the limitation 5 years has to be observed, my lord.
But
Now we have the only point.
Today, I didn't think that it will be taken up for hearing, my lord. I'll come prepared on the next date. In the meantime, they will file rejoinder, my lord.
Huh?
They have to file rejoinder also in the meantime, my lord.
Suppose we don't agree, why should they file a rejoinder? If we don't agree with Dr. Mosika, we are not going to agree with the other petitioner also. Same point. Now the issue is whether 5-year limitation apply. Two different authorities. For one authority, name the commissioner, there alone the limitation is prescribed.
My lord, in every tax law, my lord, in every tax statute, whether it is income tax, GST, central excise, my lord, limitation period is of very high importance, my lord. They cannot reopen anything
Not
after
in
it.
all cases.
But this is the,
See, even if you take into Provident Fund Authority and ESI,
my lord.
there also there was no limitation.
But that is not tax, my
Then,
lord.
now in the EPF they have prescribed the limitation of 5 years.
Well.
ESI they have not prescribed as on date.
But the ESI is a labor welfare legislation, my lord.
Whatever it is.
But these are the taxing statutes.
Compared to ESI, EPF is a much better legislation. Because the employees are going to get money.
Well. But taxing statute, in every taxing statute, my lord, the limitation has to be there, my lord. It cannot be without limitation.
It has got to be there, it is not there in this case.
But I'll place, my lord. Because the same value added tax act was there all over the country, my lord. Only the name is Meghalaya value added or Tamil Nadu value added or Bihar value added. Basically, the provisions are same, my lord.
But your lordship, I may be allowed to submit your lordship. Notices are served on the petitioner right from 17 to 23rd, 2023. My learned friend is annexed only the last notice. Did not respond to the earlier notices served on him.
No, those notices
Yes,
will
your
not
lordship,
extend the
suppressing
limitation.
all the notices, 4 notices suppressed.
I'm very sorry, my lord.
It is on
The
affidavit.
letters will not
It is on-
extend the limitation period, my lord. The so-called notice has to be issued within a certain time, my lord.
No, your lordship. It is there, your lordship. Your lordship.
I'll
can
play
come-
it because this is a very unheard
Those
of.
notices were not enclosed by the petitioner with the read petition, your lordship.
Statutory so-called notice has to be issued within.
2017 one notice, your lordship.
These notices will not. serve.
2018 one notice, your lordship. 2019 one notice also issued. 2020 also, your lordship. 2022.
What is the decision? You have any citation?
I'll place it, my lord, on the next
You
day.
don't have now.
Today I didn't think that will be taken for hearing.
Moreover, there is a.
But the matter came up yesterday also, my lord.
He's right, but at the time, we wanted to hear all the three matters. Now all the three matters are clubbed. Question which we are asking is not out of portion.
Well, that's true, my lord. Well, one opportunity, my lord.
Only out of portion questions alone will carry marks.
Any day, my lord. After once they file that rejoinder, my lord.
Tomorrow.
Not tomorrow.
You give the citation, that's the end of it. You give me the citation, beyond that, there's nothing is required.
But I thought Mr. Saraf will be arguing the other two matters, my lord, the senior counsel.
Whatever decision is going to render your case is going to applicable to him. Only legal issue.
That's a legal
Only
issue.
legal issue.
Only legal issue.
You are also taking a legal delay.
Lordship?
You are also taking the point of delay.
Yes.
Lordship. And Lordship, my point is no notice under section 35 has been issued to me. That is also a point, Lordship. After 16 years, they have opened my case.
No, the first
without
notice
giving
was issued after 15 years.
Lordship, 16 years.
16 years. But anyhow, we will see whether such notice can be issued belatedly by reading section 35, 36, 55 and 56.
Lordship.
The only point you are
Lordship,
primarily addressing is the powers of the superintendent to issue notice
Lordship.
is not brought by time limitation.
We'll
So at any point
satisfy
of
our
time. If it is a commissioner, falling under 55 and 56, the limitation of 5 years is applicable. That's the only issue.
We'll satisfy your
So,
Lordship. in the
the
next-
three matters, you can finish it. Ready tomorrow? Or Thursday. You finish it tomorrow.
But, may pray for Monday, my lord.
Lordship,
You're going to give a citation, Mr. Mosika. Your junior is there. He can give you the citation.
Only till Monday, my lord. Kindly, my lord.
No, you give the citation. Thereafter, we'll decide. First, we'll get the citation.
Lordship, may I pray for taking up the matter after a week, Lordship?
No, give the citation, sir. We'll read. Thereafter, we'll decide whether to grant time or not. Suppose we agree with you, then we'll give you time. But we don't agree with you, there's no need for time. It's a legal issue, sir. Interpreting the provisions of the value-added tax. That's all. Tomorrow, you give the citation. Thereafter, definitely, if required, we'll give you time. Because we also need to go through the judgment.
Well,
But don't bring 100 judgments.
well.
From the daily list, item number 1 and 2.
Your Lordship's right order dated 2/5/2024 had
So
directed
one other thing, Mr. Khan,
Lordship.
there are two orders filed. My brother is having one page, I am having one page. Impugned order,
Okay, Lord.
the previous case. Well, it should, the typeset should, the same page name, the page name should be there, and same page it should. Suppose he take one page, I take one other page. it's very difficult.
I don't know, they should have gone through it properly. I said,
No, the counsel, she's not there, so I'm
the
informing.
Lordship is correct, Lordship, absolutely. I'll request her senior Lordship.
See, then she would have got one order free copy, should have applied one certificate copy. It would be two different pages. But from one, she can take a printout and,
Print out and have the same copy.
or
Extra copy.
xerox it and file it. Yes.
So this is the PIL concerning the construction of the Shillong-Dawki highway. Well, it's an by order dated 2/5/2024.
I think yesterday or day before, I saw on paper that it will take time to the end of July. This,
No, that is with regard to Umiam, my lords.
Umiam Bridge.
That dam.
remember.
This was on the newspapers today, my lords, that the defense authorities have finally given permission so far as construction of some flyover is required in Shillong, my lords. That was there in the.
Then we'll adjourn the matter.
State Lordship, we filed an affidavit, just to bring on record. We have filed an affidavit, Lordship, and even today morning we received the latest instructions, so we'll bring on record also that.
You give him a copy.
Today's report, my lords, I have, but no, what has been filed, my lords, because there will be updated instructions as of today
15th
morning.
May 2024.
My lords, this I have.
This was the second last report, Lordship, but today morning we've got the latest report again. So
Has not been filed.
we'll file it within few days, Lordship.
Matter is taken up for hearing. Mr. Khan, Additional Advocate General, would submit that after the report dated 15/5/2024. They got further instructions to file another report, which is ready, and the same will be filed in due course.
Lordship, it's a progress report, not a final report. Progress report within 2 days, Lord.
The further instruction, and that will file a further report within a week's time.
Lordship.
What's the matter? When do you want?
After a week, my lords.
What's the matter?
Or let it be after 2 weeks, my lords, subject to your lordship's kind convenience. My lords, also a report would have to be called from the highway authorities, my lords, because the state is filing a report. my lords.
By the next day.
The highways authority is expected to file a report before the next date of hearing. What's the matter? During the week 17, 18, 19, 20, June.
My lords.
Some date. It depends. See, one day we are getting 2 matters, one day we are getting 20 matters. Split it accordingly.
Obliged.
Item number 4.
Of course, subject to the convenience of the lawyers also.
Made, please, Your Lordship. Made, please, Your Lordship.
Yes, Mr. Amit.
This is a writ petition filed by the petitioner challenging the MOU between the state of Meghalaya and the state of Assam regarding boundary issue, my lord. And this matter was taken up before the Honorable Supreme Court. And Honorable Supreme Court, by the order dated 30th January, has requested the Honorable High Court to stay not to proceed with the matter, my lord. So, and matter is still pending before Honorable Supreme Court.
Oh, and the matter is taken up for hearing. It is represented by Mr. Amit, Advocate General, that the matter is still pending before the Supreme Court, and that it is likely to be listed immediately after reopening of the Supreme Court after vacation, commencing on 17 May. What's the matter? On 20th August.
Grateful.
Item number 7.
Made, please, Your Lordship.
Yes, sir.
Please, Your Lordship. My lord, items 7, 8, 9 are connected matters, my lord. and the instant matter, my lord.
7, 8, Your Lordship. 9 is the
7 and 8 are connected matters.
7 and 8.
Yes. Yes, 7, 8 and connected matters.
Yes.
Lordships, I'm being led by
Yes, sir. Yes,
Your Lordship,
Vishnu.
I'm being led by Mr. Jishnu Saha, sir. I believe his connection is a little
Yes, Mr. Krishna.
Lordships, I appear for the petitioner, Your Lordships.
You
I'm
want
being
time?
led by. I apologize, Your Lordship.
Do you want time?
Your Lordships, I'm being led by Mr. Jishnu Saha. He has joined, Your Lordships. His connection, however, appears to be a little weak, Your Lordship. He has joined the present hearing. He's there online.
Oh, yes. Who is on the other side?
I am appearing for the state, my lord. The issue in the writ petition, my lord, is that central bonded warehouse was created, my lord, under the excise rule of Meghalaya, my lord. That creation of central bonded warehouse came under challenge in these two writ petitions, my lord. Now, after deliberations and after decision, my lord, the state has decided that there will be more than one central bonded warehouse, and one affidavit was filed to this effect, my lord, on September, my lord, 20. Your lordship, kindly see the affidavit of 19 September 2023.
19th?
September 2023.
Which one? 16th September, 19th September.
Yes, 19th
19th
September
2023.
was. Yes, my lord. And if your lordship will kindly see paragraph.
One minute.
I'm sorry, my lord. Kindly see the latest affidavit of 22nd February 2024. 22nd February of 2024. Second February 2024.
26. 402.
Paragraph 3 of the affidavit, my lord.
One minute, sir.
Yes.
Yes.
Paragraph 3, my lord.
Proposed state response setting up additional central bonded warehouse in the state.
House.
No, the instant between answering the respondent, nothing to say, much withdrawal. Our answering respondent objects to the proposed action by the state response seeking additional so also grounds here and below. Yes.
Yes, my lord. So, my lord, the challenge before your lordship was creation of one single bonded warehouse, central bonded warehouse. Now, to that extent, my lord, now state has filed the affidavit before your lordship, maintaining that it will create one more additional central bonded warehouse. So, as of today, there is no monopoly, my lord. So, therefore, either they have to. So, therefore, these petitions.
Vishnu, what is the problem?
I have a bit of a connectivity problem, but nonetheless, my learned friends, notifications, the amendments that they have sought to
So
make
we
to
are
the
not
court,
audible, Mr. Senior Advocate. It's not audible. I think it's from Delhi.
May I request your lordship to kindly take it up tomorrow, my lord? I'm in a poor connectivity zone.
My lord, I appear for the third respondent, my lord, who has been given the contract for the central bonded warehouse. My lord, to the affidavit filed by the state, we have filed a response, my lord. And in this matter, I am led by senior counsel, Mr. D.K. Mishra from Guwahati, my lord. So, today, due to some personal difficulty, is not available, my lord. I was praying for some time after 2 weeks, my lord.
But anyhow, the state has agreed to have one more.
That is adversely affecting our interest, my lord.
That does not serve anybody's purpose.
That
I'm appearing in item number 8.
If
I
they
am
are
also
agreed,
an
my lord, they
association of
can
bonders.
challenge it.
I am an association of
No,
bonders.
they are agreed.
The foundation of the challenge was
Yesterday, what we said that if you got any grievance, it's they say it's a policy decision, If you've got any grievance, you challenge that.
Well, this has not been taken in as a policy decision, is it? What had happened is, Malaj, originally there were these bonders, Malaj. In any state as there are various bonders. Malaj, they created a super bond. Now, when that came to be challenged before your lordships, Malaj, in these proceedings, now they've come up with an affidavit saying that we're not going to have one super bond, we're going to have more than one super bond. So that defies the entire rationale as to why there was in the first place created a super bond was created.
Which in itself is down from a checking
I'm waiting for the
Respondent number 3,
the request of respondent number 3. Post on so date.
After Milord, I will be praying for after 4 weeks, Milord. After
Yes.
4 weeks.
The dates.
Obliged.
Obligation.
Grateful, Milord.
Item number 9.
No. The date. Remind me.
Yes, sir. Please, your lordships. This matter is an appeal against a conviction in a case of 302. The sentence is life imprisonment. If your lordship comes to page 98, the impugned judgment.
We'll have it on some other day.
Malad.
Because we have already heard some matters.
Malad. Well, can it be in June, Miller? First week?
Yes, June. We'll be commencing 17th to be commencing 17th.
Okay, definitely.